May it please the board, counsel. This is a reciprocal disciplinary action brought pursuant to Part 9 of the Texas Rules of Disciplinary Procedure, based on respondent Ryan A. Beason's professional misconduct and receipt of a partially probated suspension in Louisiana. The Commission's petition for reciprocal discipline was filed with the board on December 5th of 2014. Order to show cause was issued by the board on December 10th of 2014, requiring that respondent show cause within 30 days of the order why identical discipline should not be imposed. Respondent was served by personal service on December 17th of 2014 with a petition in order to show cause by John Patterson, a private process server. Original proof of service was filed with the board on January 9th of 2015. On or about January 30th of 2014, a joint petition for consent discipline pursuant to the provisions of Supreme Court Rule 19, Section 20, that includes a joint memorandum in support of petition for consent discipline pursuant to Supreme Court Rule 19, Section 20, stipulations of fact, and a waiver of opportunity to withdraw was filed in the Supreme Court of Louisiana in a matter styled In Re Confidential Party, Bar Roll 30129, Supreme Court Docket Number 14B205. In the joint petition for consent discipline, respondent acknowledged that he violated Rule 1.14b. The rule says that a lawyer is required to comply with the minimum requirement for continuing legal education as prescribed by the Louisiana Supreme Court. Rule 1.1c, a lawyer is required to comply with all of the requirements of the Supreme Court rules regarding annual registration, including payment of bar dues, payment of disciplinary assessments, timely notification of change of address, and proper disclosure of trust account information or any change therein. And Rule 5.5a, a lawyer shall not practice law in violation of the regulation of the legal profession in that jurisdiction or assist another in doing so. On or about February 28th of 2014, an order was entered in the Supreme Court of the State of Louisiana in a matter styled In Re Ryan Andrew Beason, number 2014-B-0205, that states in pertinent part as follows. It is ordered that the petition for consent discipline be accepted and that Ryan Andrew Beason, Louisiana Bar Roll Number 30129, be suspended from the practice of law for a period of 1 year and 1 day, with all but 90 days deferred, followed by a 2-year period of unsupervised probation. At this time, petitioner offers Exhibits 1 through 3. Exhibit 1 is a certified copy of the joint petition for consent discipline. Exhibit number 1 also includes the stipulations of fact and waiver of opportunity to withdraw. Exhibit number 2 is a certified copy of the order filed in the Supreme Court of the State of Louisiana. And exhibit number 3 is an original certificate from Blake A. Hawthorne, Clerk of the Supreme Court of Texas, dated January 7th of 2015, which indicates that respondent is licensed and is currently authorized to practice law in Texas.
Mr. Crocken, do you have any objections to Exhibits 1 through 3?
I do not.
They'll be admitted. You may.
Petitioner seeks a partially probated suspension as reciprocal discipline pursuant to Part 9 of the Texas Rules of Disciplinary Procedure.
Thank you. Any questions at this point?
Yeah. Ms. Stevens, the reason I asked questions of Ms. DeBerry in the Hickman case was in that case, which involved active dishonesty by the lawyer. It's a case also where the client suffered harm in the sense that the statute of limitations ran on her unfiled case. That attorney received a sentence of 1 year, unprobated, whereas Mr. Beason received a sentence of 1 year and 1 day with all but 90 days probated. I struggle a bit here. I recognize and do not excuse the failures of Mr. Beason, but it seems to me that the sentences are disproportionate just looking at 2 Louisiana cases. Would you care to address why you believe that even under Texas law that this sentence was warranted?
I will, of course, address your question. The the rules under Section 9 of the Texas Rules of Disciplinary Procedure require the commission to bring forward any discipline from another jurisdiction. And the truncated process is such that in Louisiana, they were to consider any mitigating evidence, anything that would warrant less or more discipline. And so I would point out that it is now the respondent's obligation to present the defenses that are listed in Section 9. And then if he's successful in then doing that, then I could respond to a little more about what appropriate.
Well, it seems like the best answer is he pled to it. Right.
In our case, yes. I'm not familiar with the Hickman case, but yes, in our case, it was consent.
I guess what I was trying to get, and I'll wait, because you make a point that there are certain defenses that can be raised, and I'll wait for rebuttal if it's not addressed by Mr. Carrano.
Any further questions? Thank you. Mr. Crockett.
Board Member Black has made my argument for me, so I don't have much left other than to point out a few things that may not have made their way into the answer we filed, which I'm sure all of you've read. This is, if there is such a thing as a non-culpable violation of a disciplinary rule, this is it. The story simply is that Mr. Beason had a law license in Louisiana, which he rarely used. He was asked back in 2012 to handle a family law matter over there. He knew that his bar dues were delinquent in Louisiana. He knew that he had not kept up with his CLE in Louisiana. So he made a phone call to a person with the State Bar of Louisiana and asked what he needed to do to get reinstated to where he could properly practice law in Louisiana. He was erroneously told that all he needed to do was bring his bar dues current, which he did by sending in a check for $850. He was also told on the phone that he needed to get his MCLE in Louisiana up to date, but that he would have until the end of the year to do that. That was erroneous.
I apologize for interrupting. I anticipate that there will be testimony in this regard, and that this is just an opening, but if not, then I would object to counsel testifying on behalf of the respondent.
Mr. Crockett, do you intend to offer evidence?
I do, Your Honor, if that's what you'd like to hear so far.
I'm
representing that this is what I believe I can prove.
All right.
Thank you.
This is my opening statement as to what my evidence will show if I'm given the opportunity to present that evidence. The story is that he was misinformed as to what he should do and was needed to be done before he could properly file pleadings and make an appearance in Louisiana. Now, should he have relied on an unidentified lady on the phone to tell him what the law required in Louisiana? No, that was a mistake. He shouldn't have done that. He acknowledges that. The fact is that he needed to do more. He needed to pay his bar dues. He needed to get his MCLE up to date now, not by the end of the year. And he needed to get his new law firm registered with the IOLTA account, which is another requirement of the State Bar of Louisiana. He had to do all three of those things. He only did one of those three. But he believed that paying his bar dues made him eligible to practice again in Louisiana. He was wrong. He filed pleadings in a matter in Gretna, Louisiana, in the 24th District Court over there in a family law matter. And he made an appearance for a hearing for his client in that same court where he had filed the pleadings. The commissioner, which is the official of that particular court, not the judge, but like a deputy judge, looked him up and realized that Mr. Beason didn't have a current valid law license in Louisiana and reported him to the bar officials. And then everything that Ms. Stevens recited unfolded. Mr. Beason was not very active in Louisiana. His practice is located almost 100% in the southeast Houston Clear Lake area where he does a family law practice. He was faced with having to try to fight it out with the state of Louisiana or cut his losses, admit that he had done something inappropriate and make a deal, and he took the latter course and accepted the discipline that Ms. Stevens has accurately outlined. A 1 year and 1 day suspension, 90 days actively served, followed by 2 years of unsupervised probation. He did that to save money and because it wasn't going to hurt him, because he didn't really practice law much in Louisiana. But now then, what we're faced with here in this forum is the same identical discipline that Ms. Stevens is advocating for in his home state, where he has his office and practically 100% of his practice. 90 days off in Louisiana is one thing for Ryan Beason. 90 days off in Texas is an entirely different thing. And we take the position that Rule 4.02C makes the exception to the general requirement of automatic reciprocal discipline, that if the discipline this body imposes would represent a grave injustice, then you're not required to impose the same discipline that the state of Louisiana did. And if you impose the same justice that Louisiana did, it will in fact result in a grave injustice, because it will deprive him of his livelihood. And I'm not going to brag on him more than I did in the answer, but he's an extraordinary lawyer with many accomplishments, double board certified already, and about to be board certified in a third specialty. He's done a lot of pro bono work. He has an excellent reputation in Houston, Harris County, and to impose this discipline on him would be disastrous for him, and he doesn't deserve it.
Mr. Krotkin, first of all, good to see you after all these years. Second, is there any opportunity for Mr. Beason to go back to Louisiana and do anything to undo what's occurred here? Because it seems to me, I share Mr. Black's concern to some extent, but as is pointed out, this was agreed to. Understand he didn't understand that there would be reciprocal discipline here, and I certainly understand and appreciate that. I don't know how many lawyers understand that who are sort of, licensed in other states, but that is the law. And so my question is, are you aware of anything he can do now such that he doesn't face that discipline any longer or can do something about it?
My understanding is, and he will correct me when he testifies if I am wrong, is that since all of these events have occurred, he has in fact done everything that the state of Louisiana asked him to do and that he agreed to do, and that he now has an active law license in Louisiana and can go back there and practice like anybody else with a Louisiana
Well, I guess
license.
I understand that. I assumed there were certain conditions here that he remained fully eligible throughout the period of probation, so I assumed he had done those various things. I assume he's got his CLE and all that up to date. I'm not worried about that. I guess what I'm asking is there some way to go back and in effect expunge it? And I don't know if that's even a good word to use here.
Mr. Kidner, I don't know the answer. I am not a Louisiana lawyer. I've not studied their bar rules, and I simply don't know.
Thank you very much.
If he had contested all of this in Louisiana instead of stipulating, what would you consider to have been a fair outcome in Louisiana?
Maybe a public reprimand, maybe a fully probated suspension of a year and a day.
Thank you.
Are you going to call your client as a witness?
I certainly am. If Ms. Stevens is challenging my statements about what the evidence would show, I
Because I have some
certainly
questions,
will.
but I don't know if they're properly directed to you or to him, so.
Let me ask this question. Ms. Stevens, you've made an opening presentation. Do you have any further evidence to offer?
Not at this time.
Are you ready to offer evidence at this
I
time?
am, sir.
Let's do that.
State your name, please.
Brian Beason,
Mr. Beason, are you a member of the State Bar of Texas?
yes.
Since when?
November of 1986,
When did you become a member of the Louisiana Bar?
in 2005.
Did it come to pass at some point that you got behind in your bar dues and your other requirements for membership in the Bar of Louisiana?
Yes, in 2000 and 2008, I stopped practicing over there altogether as I was no longer doing silicosis and asbestosis work over there, and really had no intention, once I entered into family law, really had no intention at all of going back over to Louisiana.
Back in 2012, what happened that changed that?
The firm approached me and they had some workers' compensation cases over there, and they were interested in having me do something over it. I prepared a pleading that was never filed on that, but we also had a family law client who had dual proceedings going on. One was a divorce and another was a child custody, and it allows that could simultaneously go forward. The only thing we asked was the Gretna court to decline jurisdiction and allow everything to proceed in Texas.
And did you recognize before you embarked on that you were not authorized to practice in Louisiana?
Never. In fact, there were email exchanges between myself and another person in the firm in which I was saying, and look, I took care of this issue, I paid the fees, they're telling me I'm fully fine. And my understanding regarding Louisiana is you have to complete the necessary MCLE in the years that you practice law there, not in every single year. And so since I wasn't practicing there, I didn't think I had a CLE requirement that had to be completed until December 31st following any practice in the state.
There's also this requirement, I understand, of having your firm's IOLTA account registered with the state of Louisiana. In 2012, when these events arose, were you aware of that requirement?
Yes.
Okay. And so what effort did you make, if any, to get your IOLTA account established before you filed the pleadings and made the appearance over there in Gretna?
I didn't.
All right. Were you aware then when you filed the pleadings and made the appearance that you weren't supposed to be doing that, for lack of a better term?
No, not at all.
You thought you were authorized to practice in Louisiana?
I would have never gone over there.
Did anybody with the clerk's office or any representative of the judge call you in advance of either the filing of anything or the appearance in court and say, wait a minute, you're not authorized to practice here?
No, I filed the pleadings. We had one hearing, and I went forward on the hearing, and Judge Bailey or Reuben Bailey chided me because I prepared my pleadings on 8.5 by 11 paper rather than legal, but he denied my declinatory exception, and at that point in time the client just decided to allow them to go forward with the divorce and the divorce only in Louisiana, and then proceed forward with the SAPS, or the suit affecting the parent-child relationship, in Texas. And so we didn't do anything further over there. We didn't go to any of the other hearings, and it was at that later hearing that I guess Reuben Bailey looked me up and was wondering. But I would have never gone over there, and I had email exchanges within my firm saying, no, I've taken care of this, I paid the fees, and everything's fine for right now. So I never suspected that there is any problem. Texas issues a cease and desist letter. Louisiana does not do that. And I had my fee dues, I called and contacted them, but I didn't know there was, actually there's a list over there that you ought to check on yourself rather frequently to see if you're on the list or off the list. And if you're not on the list, you shouldn't do anything over there. I now know that.
When you were in court before Judge Bailey over in Gretna, did he say at that time that you shouldn't be there, you weren't authorized?
No.
As best you know, did your clients come to any harm as a result of you being over there and doing what you did without an active Louisiana law license?
Not in the slightest.
The next thing that happened was what? You heard from the State Bar of Louisiana officials that there was a problem.
Correct.
And tell the members very briefly how the problem was ultimately resolved.
I filed my answer, and in fact I demonstrated my lack of any knowledge of any of this by my emails with other members within our firm. And in filing those emails, I guess I basically proved their issue that I should have been more on notice. But I truly believe that I was fully legal to go over and conduct that hearing, or I would have never done it, not in 1,000 years.
You learned, without any question though, that you weren't in fact authorized to do what you did, so you violated their rules, right?
Correct.
Okay. Then arose the issue of what do we do about this? And you ultimately decided to stipulate to the violation and accept the offered discipline, which was a 1 year and 1 day suspension, 90 days actively served, the rest probated, followed by 2 years of unsupervised probation. Is that right?
Correct.
Why didn't you fight it out?
Well, I wasn't planning on practicing up there. I even explored the idea of just surrendering my license because I never had any plans. The opportunity for a family law attorney to go over there, it's just very, very rare, and I never had any plans of ever doing that. And so, but it wasn't going to be cheap either to even just surrender your license. It was going to, and so I just am, the disciplinary counsel over there convinced me not to surrender the license and just take the probated sentence. So it was either that or go over for a hearing in New Orleans. And as much as I like New Orleans, I didn't want to go over and spend 2 days and go through that. I just chose to do a 1 year suspension.
During the course of making this decision to agree to the offered discipline in Louisiana, did it occur to you that you would be subject to reciprocal discipline in Texas?
Never.
Now, Mr. Beason, have you ever been a member of the State Bar Grievance Committee?
Yes.
Here in Texas?
Yes, for 6 years.
6 years. Did you have a reciprocal discipline issue come up before your committee when you were on the grievance committee here?
I served for 6 years in the last 2 months as chair, and I never had a reciprocal discipline issue come up.
What is your excuse for not realizing that there would be reciprocal discipline based on what happened in Louisiana?
Complete ignorance.
In retrospect, do you wish you had handled it differently had you known about the reciprocal discipline?
Absolutely. I think if I had retained somebody and gone over and fought that, I could have gotten something less than a 1 year complete suspension. That was my mistake.
Tell the board members, please, how much the discipline in Louisiana has hurt you financially.
Well, my letter that I have to I've already paid a $1,000 fine, and I have to pay another $1,500. So it's been substantial.
Mr. Crockett, I have a question. Does Louisiana permit the filing of pro hoc vice motions? In other words, where someone can appear for limited purpose of that one proceeding?
I think so, but I really don't know. I don't practice in Louisiana at all.
I guess the issue, the reason I'm asking is, would Mr. Beason or someone similarly situated be able to avoid this problem in Louisiana through the filing of pro hoc vice?
I would presume so, because every American jurisdiction that I'm aware of has at least some provision for pro hoc vice appearances.
Though I wonder if you can pro hoc when you're already licensed in the state.
And
that seems inconsistent.
I don't know.
I just don't know, sorry.
I think I know the answer to that question. Louisiana does allow pro hocs, but they are very restrictive of people doing that in their state. And so when I was routinely going over there on silicosis and asbestosis cases, there was no way that they would allow you to pro hoc in that much. So it was incumbent upon us, my client's request, that I get admitted there. So I had to go take that 5-day written exam over there, and so there is the possibility, but they are probably one of the most protective states regarding pro hoc opportunities.
Thank you. Mr. Crockett, I want to go to your argument on grave injustice. In almost every case where someone appeals one of the reciprocals, they claim economic harm, and they can almost always prove economic harm. That's almost a predictable consequence. Given that, besides economic harm, what else do you allege constitutes a grave injustice if we impose reciprocal discipline? Any testimony that y'all have as to that would be of interest.
The discipline that he gets, unless it ended up being a private reprimand, which I think is probably out of the question, is published in the Bar Journal. He practices in a relatively small community. It's not Houston proper, it's Clear Lake City. He does a family law practice, so the consequences of being published in the Bar Journal with any kind of discipline, leave alone a suspension with some of it being active, is going to be devastating to his getting clients and getting business and getting referrals. Most family lawyers, I think, I don't do family law, but I suspect that a lot of family lawyers get a lot of their business on referrals. If you have 2-3 lawyers that you can refer cases to and one of them's suspended or has a disciplinary history and the other 2 don't, I'd rather suspect you're not going to refer to the one who has the disciplinary history. And so it's disastrous to him based on reputation, the prospect of having additional referrals, new clients coming in. It's the age of the internet, word about things like this gets around. And so it's not just 90 days of not being able to charge money to practice law. It's implications going far, far beyond that. And my real issue is what Mr. Black raised, and that is all of these same actions and things that have gone on in Louisiana have not really adversely affected him because he doesn't live there and he doesn't really practice there. So doing that to him in Louisiana is one thing, doing it to him in Texas is an entirely different thing, so that the punishment in Louisiana is fair, if you will. The same punishment here is grossly unfair. It's grossly disproportionate to the offense.
Are you suggesting no punishment here?
No, I'm not. I absolutely
Well, I
not
mean, I
suggesting
understood
that.
you to say that even a public reprimand would be hurtful to him.
Well, it would, but it would certainly be less hurtful than an active 90-day suspension.
No, I understand that. I just want to make sure whether you were arguing that we should do nothing.
I am not
say boys will be boys in Louisiana. And let
No,
it go.
Mr. Gurwitz. I mean, he violated the rules over there. He agreed he did. There's no issue that he did. He should have educated himself, quite frankly. That's the biggest problem that I have with this is a bright, well-educated, experienced lawyer who was on a grievance committee for 6 years and yet didn't know that he would be subject to reciprocal discipline based on this deal that he made in Louisiana. But when you get to the bottom line, did he violate their rules? Absolutely. Should he not have known better? Absolutely. So punishment's in order. It's the gravity of the punishment, the severity of the punishment that gives me the heartburn.
Mr. Beason, before we go much further, let me ask you, if you were asked by counsel the questions regarding harm to your practice, as Mr. Karakin just outlined those so succinctly, would that be your testimony?
Correct, Your Honor.
In that event, I pass the witness.
In terms of what happened in Louisiana, I don't know what proof. Let me ask you, Mr. Beason, did you have any email correspondence or anything of that nature with whoever you talked to confirm that you had gotten bad advice? Or was it all over the telephone?
Yes, and let me tell you.
Yes, I asked you 2 questions, so which is yes to? That was my fault. Did you have anything in writing about the advice that you received?
Regarding a reciprocal discipline?
No. You said you were told that all you had to do, you understood that all you had to do was get your CLE in order for 1 year as opposed to all the years that you had missed, correct?
Right.
And do you have any of that in writing?
Yes, I have the letter from Denise Tingstrom in which, and there's 5 different portions in Louisiana, and you've got to make sure that you are fully compliant with each of the 5. And Ms. Tingstrom, all she was doing was telling me, you're current on your bar dues. I perceived her letter as being, you're okay, because of the requirement that CLE be completed by December 31st in the year in which you're practicing over there. So that's why and I should have read the letter fully and more closely, because it did say further down that you've got to take care of these other things also.
Well, I guess my question really is the following. I don't know what the discipline would have been in Texas. I've been on the grievance committee just as you have, and I'm trying to remember even one of these coming. I think they all get resolved at some point. But if you had fought this in Louisiana, do you have any indication that you would have gotten, either you would have won or they would have sought something even more because you agreed to 90 days in effect, correct?
Right.
So I'm just wondering what would have been the outcome given what you have here in terms of proof, because it sounds like to me they're pretty hard over there.
Yeah, but I think that they do have the options of public reprimand, and if I had gone over, retained counsel, and done a contested hearing, that I would have probably had nothing more than a public reprimand over there.
I have a question about some statements that are contained in your response or your answer to the petition. There's a paragraph that references your board certifications, and it also says that respondent took the examination to become board certified in a third specialty family law in October 2014 and is awaiting the result. It's my understanding that that application to take the exam would have been completed in June or July and submitted to Texas Board of Legal Specialization. Can you confirm that?
Correct.
And did you disclose that you had been disciplined by the state of Louisiana on that application?
Yes, I did. Well, wait, let me explain first of all on that. I was a repeating because I had taken the family law certification test the year before. So all I had to do was to repay the exam fee, and then I was automatically in line for again. There wasn't a complete reapplication necessarily.
The application states that you have a continuing duty to update the disciplinary portion of that. Did you do that?
Correct.
You did that in 2014 after you had been disciplined by Louisiana?
No, by that time, none of that had taken place. I reapplied in March or April of 2014 to take the exam, and I don't think I received anything from Louisiana until later on in 2014.
The order in Louisiana was entered February 28th, 2014.
Correct.
Before you took the certification exam.
Correct.
While you had a continuing duty to disclose to Texas Board of Legal Specialization any disciplinary actions.
Correct.
Now my question again is, did you, after February 28th, 2014, and before you took the exam in October, disclose the order that had been entered by the Supreme Court of the state of Louisiana?
If that came up to a question to me on that, I would have disclosed that. I don't know that when I reapplied for retaking the exam, they gave you an expedited process if you are just applying again to take the exam that you took the year before. And I don't think that I was asked anything on that, about that, but I have been disclosing this ever since the questions come up, because I was asked by the Southern District when I reapplied about this, and I have disclosed it.
And did you take the exam in October?
Correct.
And did you pass the exam?
No, ma'am, I did not.
Further questions from the board?
Yes, Mr. Beason, there is a process by which lawyers certify certain information annually, and it's posted on websites on the State Bar database, dealing with identity and dealing with background and other matters. Your public profile shows a last certification on May 23rd, 2014. That is about 7-8 months ago. Do you recall that annual process as something you've done from time to time?
I can't say that I do recall that. I know I have disclosed this with the Southern District because it's come up, and I have disclosed that, but I don't remember anything in that process where I was called upon to disclose that.
The public database site under other state sanctions says none reported by attorney. Have you given any attention to trying to correct the database?
No, but I will immediately.
In Louisiana, you continue to have probation for an additional 1.5 or 2 years?
Correct.
So there is a current disciplinary process in Louisiana. Have you taken steps to explore how you might ask to modify the discipline imposed in Louisiana?
No, I have not.
In the Louisiana proceeding, the records that are in evidence now indicate that you stipulated that your violations were knowing. Do you recall that?
Yes, I did.
Could you help us understand why you signed a stipulation that your violations as to the CLE and also as to the IOLTA trust were knowing?
Because I did not want to go over and fight and contest that. I was told, here are your options. Either one, come and fight and contest, or two, agree to these papers that they put together. It was the path of least resistance.
Was it truthful or was it not truthful to say that it was knowing on your part that there were violations?
No, I did not. There was never a knowing violation on my behalf on that. I would never have gone over and done that.
What do you think ought to be the consequences of signing a formal stipulation in a judicial process that's not truthful?
I don't know. I don't.
Mr. Beason, by knowing, you mean you had no intent.
Correct.
You're saying because you've admitted that you knew about the IOLTA issue.
Correct.
And you knew that there were requirements that you didn't fulfill. But when you say it's not knowing, it's that your defense is that you did not intend to violate any disciplinary rules in Louisiana.
Correct.
May I make a comment on this? I'm running the serious risk of parsing words like lawyers do, but there's a big difference between knowing and intentional. Knowing means he knows that he was filing the pleadings. He certainly knew he filed the pleadings. That's knowing. He knew that he appeared in court for a hearing. That's a knowing action. But he did not know or appreciate that those actions were unauthorized under the law of the state of Louisiana. Had he known the latter, then it would not just be knowing, it would be an intentional violation. So that's the distinction, and that's why, in my mind, for him to say, I knowingly did these things is not a lie or false. It's an acknowledgement that he took action knowing that he was taking that action. Knowing that he took it's different from knowing that it's wrongful.
This question is for Mr. Beason. Mr. Beason, during the time that you were making the agreement with the disciplinary council in Louisiana, did it ever come up, did you discuss with them about your practice in Texas?
Never came up. And in fact, I'll have to say Charles Platzmeyer, the general counsel for discipline over in Louisiana, was very courteous and appropriate in dealing with me at every time and promptly responded to all of my requests and emails. The only email he never responded to me on was when, after I got this notice, I sent him an email back saying, did you know this would occur? Mr. Platzmeyer never responded to that email.
So they never asked you whether you had any other licenses in any other states?
Never.
And then did not talk to you about the scope of your representation in another state other than Louisiana?
No.
Ms. Palome, I just need to say that the papers that you have that I was reading last night clearly recite and clearly reflect that Mr. Beason had been a member of the State Bar of Texas since 1986. So if your question was, did the Louisiana Bar folks know that he was a Texas lawyer, the answer is absolutely yes, they
No,
did.
my question is, did they discuss the scope of his practice here?
Korokin, one more question. You were asked about grave injustice and
Well, let me just do this. Are we through with the testimony from the witness?
No, I have a question. Mr. Beason, I'm a bit confused at the moment about awareness and intentional and knowing. What's your testimony on the IOLTA account? Were you aware of a requirement in Louisiana?
Yes.
Okay, tell me how it is in the answer at the bottom of page 2, the last 2 sentences. There was also a requirement that he register the IOLTA account at his new law firm in Louisiana. Because he was unaware of this requirement, he did not register the IOLTA account.
I had a fully registered IOLTA account when I was on my own, and that was there, and I didn't see any problem with that. And when I moved to another firm, yes, but I never realized or had any intention when I started on with the new firm to do any practice over there. I still had my fully, completely registered IOLTA personal account in Louisiana, and that was registered in Louisiana. The only thing I didn't do is create a new firm account for Bailey and Gallion to have a registered IOLTA account.
Okay.
Other questions for the witness while he's testifying?
Mr. Beason, what do you think is a just result of this proceeding? And my next question will be, why do you think that?
I think a fully probated sentence would be appropriate. I think I've been punished enough for what I did in Louisiana. I mean, I've got another $1,500 to pay in fines and penalties in Louisiana. I've got to get fully reinstated in Louisiana before I can even get my application with the Southern District back. So I have to go through with that entire process to get that license back before I can even ask for inactive status there. I don't plan on practicing in Louisiana fully, but I am going to, for this year, I'm going to have to do the CLE, I'm going to have to register the accounts, I'm going to have to do everything, and I've gotten a letter from the disciplinary council over there about everything I need to do to get myself reinstated there. So I'm going to be going through that process right now.
Mr. Beason, what is your status with your law firm right now? Are you an employee, or are you a partner? Or
I'm an employee.
Mr. Beason, when you said a fully probated sentence, are you saying that it should be the same 3-year probation that you, in essence, that covers the 3 years in 1 day, I guess, of the full Louisiana?
Yeah.
Anything else? Ms. Stevens, you haven't had an opportunity to cross-examine.
I have no questions.
All right.
I do have one for Mr. Korokin. This is the last thing.
Can witness be excused?
Yeah, sure. I'm sorry.
And then are we at a summation stage? Do we
I just
think?
have one question.
All right.
And the question is, we were talking about grave injustice, and as Mr. Black said, economic harm was what was indicated, and we have those every time. I'm just trying to hear something that's not economic harm, because again, everything that I heard seemed to talk about economic harm. Can you tell me something that would not be economic?
Yes, sir. Mr. Beason is a pro bono champion. He has a picture. I didn't bring it, probably should have. He has a picture that he sent me that says that represents his proudest moment in his practice of law, of 2 young African-American kids whom he helped to be adopted by their maternal grandmother when their father was in prison and their mother had died. He does this, and this is not an isolated thing for him. He's a pro bono champion in Houston, takes at least a couple of cases a year from Houston Volunteer Lawyers Project. He does charity work, legal work for members of his church. And so if you suspend his law license for 3 months, he can't do that either. He not only can't make a living, he can't even do the pro bono work because it's practicing law. So I guess I'm asking you not to take away Ryan Beason from the poor folks who need his help.
Thank you.
You may be excused as witness. Are we ready for summation? 10 minutes of side work?
Yes. Shall I go first?
You may proceed.
Oh, I thought I might take questions from the board since I didn't answer any earlier. Is that okay?
Can't hear.
I thought I might take questions from the board since I didn't take any earlier. If
Well, that's
you would
brave
like-
of you. Does the board have any questions of Ms. Stevens?
Or
I've invited it.
Well, let me just ask this in lieu of
There you go.
Well, I mean, I don't think, just from my standpoint, I don't need a closing argument. I just need an answer from you on a couple of questions. And I think, as Mr. Black pointed out earlier, it does seem a little harsh for missing your CLE. I know the rules are the rules, and I know there are exceptions when it's reciprocal discipline, but what is your response to that? Is it just sort of, that's the way life is?
Well, it's not that's the way life is because there are 5 defenses that...
I understand that, and I'm just saying, tell me how you think this is appropriate.
Well, I think the defenses that the respondent touched on are C, grave injustice. That grave injustice would occur if you impose reciprocal discipline or identical reciprocal discipline. And then they touched on it a little bit on D, whether it warrants substantially different discipline in Texas. So not that he would get no discipline, but it would be different than what he received in Louisiana.
Well, why don't you answer the second one, because I think we beat the grade one up some.
Well, I took the liberty of looking at some cases where this was the only rule violation was the practicing while administratively suspended, and I found anywhere from a private reprimand up to a year partially probated with a month active. And
Sorry,
so
with the year?
a year partially probated with a month of that active. And so there's a range there that Texas has deemed appropriate in our evidentiary or settling cases for the same misconduct. I think it's the board's determination whether he's proven that defense under D, that it warrants substantially different discipline in Texas, whether he's proven that by clear and convincing evidence. I would point out that the last sentence under Section 9 is that if the Board of Disciplinary Appeals determines that one or more of the foregoing defenses have been established, it shall enter orders as it deems necessary and appropriate. So you do have discretion there if you decide that he's proven that defense by clear and convincing evidence.
Ms. Stevens, a couple issues that I want to get the Commission's take on. First, frankly, the IOLTA account is of some concern to me. Did the Commission have any take on the issue of Mr. Beason's testified that he had an individual IOLTA account and assumed that that was good enough? Do you have any information that that testimony is false or incorrect?
I do not have.
Second, and this concerns me as well, frankly, and that is the answers to some of the questions from Ms. Kinzer and Mr. McKetta in terms of Mr. Beason's duty to update and keep current materials in Texas. Have there been prosecutions in Texas for someone who has not updated a board specialty exam other than not being able to sit for it?
I appreciate that question so much. I had a note to mention it, and I'll address them separately because they are 2 different things. I don't know of any prosecution based on a failure to update on a board certification application. That doesn't mean it hasn't happened. I don't know of any off the top of my head. As for what Mr. McKetta was addressing, I can't remember if it's in the bar rules or where it is, but there's an obligation to report that you've received discipline in another jurisdiction. The annual update that Mr. McKetta addressed with Mr. Beason I've looked into it a little bit, and I did not anticipate this question, or I would have looked into it more, and I'm happy to give you all more information. But in fairness to Mr. Beason, you may be able to comply with that rule that Mr. McKetta was talking about without providing the other jurisdiction discipline. It's been confusing for me, and so I would hate for the board to hold that against him when I can't tell you for sure that would be its own violation, if you will. In addition to that, I update mine online, and I couldn't recall off the top of my head sitting there whether you have to affirm that you haven't been disciplined in another state or not. And so I just wanted to point that out.
Does the commission always seek equivalent reciprocal punishment?
I think under the rules, we have to bring the petition as is and ask for reciprocal discipline identical, and then the respondent is obligated to prove up their defense.
But you're not obligated to do that. You can do less than that, can't you? Or more than that?
Well, you mean we could settle the case or something like that?
Yes, you can ask for more punishment or less punishment.
I don't think that we are allowed or able under the rules to ask for more punishment.
So the commission always asks for identical punishment, no matter what it might, how it might bear on what would have occurred in Texas?
Every time I've filed a reciprocal discipline, yes, that's what we've asked for, identical discipline, and then put the onus on the respondent to prove up one of the defenses.
I couldn't find in the record how Texas became aware of Mr. Beason's sanctions.
Give me just a moment, I can find out.
Thank you.
Louisiana sent us the order, and I think we had to ask for the prior order, the decision that had more detail in it. And so Louisiana did send it to us, though.
Thank you.
Mm-hmm.
Other questions for Ms. Stevens?
I have a question. I'm looking at Rule 9.01, which I think does make it mandatory that you file papers that you filed. That doesn't mean it's mandatory what relief you ask. And you made the comment earlier about the last sentence of 9.04 about if a defense is established, such orders as the board deems necessary and appropriate. So my question to you would be, do you have any recommendation to the board for what you perceive would be a necessary and appropriate order?
I don't have an answer that would be satisfying. The reason I got the range of discipline that's been imposed in Texas is I thought that the board might want some guidance in that area, but I do not have from the commission a stated other discipline that I could ask the board for.
In other words, you're not authorized to speak.
Yes.
Perhaps you're reluctant to ask for relief that your client is not asking for. All right.
Anything further?
I know the feeling.
Thank you.
Thank you, Ms. Stevens. Mr. Kratkin?
I am authorized to speak. The one thing that I do want to point out, since we've gotten to this issue of what's the appropriate punishment, is one of the exhibits you have before you is the joint memorandum in support of petition for consent discipline pursuant to the Supreme Court Rule 19, Section 20 in the state of Louisiana. And in here they set forth what they call the jurisprudence of the state of Louisiana relating to this offense and the punishments that the jurisprudence shows have been given to Louisiana lawyers for doing, quote, similar, end quote, things. If you take a look at that, and it only takes a few minutes to read this, you'll see that in each and every one of these cases they cite, it wasn't just practicing law without a license or while administratively suspended. Every one of these cases, as best I could tell, involved several aggravating factors. Conduct involving dishonesty, deceit, and misrepresentation, multiple prior findings of violating the rules, and some really bad stuff. And so, not surprisingly, the disciplines meted out in those cases, according to that jurisprudence, every one of them included a suspension. In fact, every one included an active suspension, except for one where the lawyer had been guilty of so many other things that they disbarred the lawyer. So I'm only bringing this up because if you read that and you compare the facts of those cases as reflected in the court's opinions with what we have here, I think it really shines a spotlight on how meting out the kind of discipline that the Supreme Court of Louisiana was giving in those cases is just grossly disproportionate to what Mr. Beason did. It's just not fair.
Mr. Krotkin, I need to go back once again to your client's signature on a page filed with a judicial proceeding, because the memorandum that you've just described is a joint memorandum of law, is it not, signed by your client, containing the phrase, given the respondent's past history of various periods of ineligibility. This is just prior to the conclusion. The terms and conditions of probation appear most appropriate, and that follows the sentence that he recognizes he will be, quote, subject to the full year and a day active period of suspension, close quote, before probation. So even reviewing those authorities, it's your client's signature indicating the full year and a day, and also indicating that probation in addition is appropriate. This is the 2-year period because of a past history of ineligibility. Do you know what that's referring to?
I believe it, and Mr. Beason can speak definitively to this if you like. My best recollection is that he had had periods of time when he was not practicing in Louisiana prior to 2012, when he hadn't paid his bar dues, he hadn't done his MCLE, and he was therefore administratively suspended, going all the way back to, I think, 2008, and from time to time after 2008, up until these events in 2012 or 2013, he had intermittently been administratively suspended due to not paying his dues and not doing his MCLE.
Well, counsel, I think it's 2010. The issues are set forth in the first page of the joint memorandum. But the conduct this refers to and the consequence is not being able to practice in Louisiana, isn't it?
Yes.
As opposed to Texas.
Yes.
Further questions? Thank you, Mr. Krotkin. Ms. Stevens, you have the burden of proof. Do you have anything further?
The commission rests.
You're not inviting further questions? All right. Thank you. The board will take this matter under advisement. This concludes the public hearings that we have set on the docket.